The greater percentage of us are neither creators nor inventors of anything. We simply consume what others create, invent, produce, sometimes to the extent that we begin to project other persons' creations of their minds as our very own. While we're not expected to reinvent the wheel, we must be cognizant of how we use other persons' creation. And this is critical. This issue is so serious, so prevalent, that laws have been enacted by sovereign nations worldwide to protect creations of minds. We are discussing Unit 1, Module 1, sections which covers intellectual property, patents, and copyrights of the CAPE Digital Media Syllabus. The question may be asked, what exactly is intellectual property? WIPO, World Intellectual Property Organization, describes intellectual property IP as creations of the mind. We're looking at inventions, literary and artistic works and symbols, names, images, and designs used in commerce. There are actually two different distinct categories when we're looking at intellectual property. They're industrial property and copyright. We'll take a moment to look at industrial property. Industrial properties can be inventions or patents, and this is exclusive rights granted to an inventor by the state in exchange for public disclosure of inventions. In other words, it's a protection that is granted to the inventor. For example, if a person invents a machine that is supposed to recognize persons when they enter a room by their face, then this person is granted, either himself or somebody who is assigned, protection by his sovereign nation, so that no one else can claim rights of this particular invention. There are trademarks, which are recognizable signs, designs, or expressions, which distinguishes products or services of a particular source from those of others. And most companies have their trademarks. Flow, for example, has its own trademark, and this distinguishes Flow from another service provider in Grenada, for example. There's industrial designs, which are the use of both applied arts and applied science to improve the aesthetic, ergonomics, functionality, or usability of a product. And it may also be used to improve the product's marketability and even its production. How about geographic indications of source? This also is described as industrial property. A name, which is a name or sign used on certain products, which corresponds to the specific geographical location or origin. For example, a town, the town of Guave in Grenada, or Sotez, or Grenville. A region, we can talk about the OACS sub-region, or a country, Grenada, for example. The use of GI may act as a certification that a product possesses certain qualities, is made according to traditional methods, or enjoys certain repetition due to its geographic origin. The other category is copyright, which includes literary and artistic works such as novels, poems, plays, films, musical works, artistic works such as drawings, paintings, photographs, sculptures, and architectural designs. So what about the rights? Rights related to copyright include those of performing artists in their performances, producers of phonograms in their recordings, and those of broadcasters in their radio and television programs. When we look at digital media, there are a number of intellectual property issues that goes hand in hand with it. The proliferation of digital assets has created questions about how to apply traditional copyright laws to intellectual property related to digital media. Such questions has to do with, for example, the capabilities and characteristics of digital networks technologies. E-commerce has had a tremendous impact on systems of copyright and related rights, and the scope of copyright and related rights in turn is affecting how e-commerce evolves. We know that we're in an age where everything happens online. The internet is very pervasive. Everybody is doing things on the internet, and commerce has taken quantum leap on the internet. Now, the whole question and issue of copyright can impact how e-commerce itself evolves. What laws are there to protect persons and how persons can transact online? Copyright leads to certain such issues as plagiarism, unauthorized use, and derivative works. The salient points that we need to note is that while the internet, no one owns the internet per se, and we can go online at any time and visit just about any site anywhere online and use works of persons, we need to be cognizant, and this is quite important, of how we use other persons' work. Just as traditionally in the analog world, it is important that we don't claim another person's work. For students, for example, when you're going to do a paper, you must recognize that you need to bibliograph your source of information. Likewise, in the digital world and with DM, you need also to bibliograph your source of information, and this is quite critical. Persons have been prosecuted and there are laws, while in some countries, still in the Eastern Caribbean, in the OECS, for example, the laws are not yet in place. They're being drafted, but not yet in place, not yet enacted. There are laws to protect persons' rights and creations and inventions. So we need to understand that, and we need to be at all times cognizant of the fact that we are using other person's work. While we're not expected to reinvent the wheel, but we are expected to recognize, give recognition to the source of our information online.